This is a short video on the topic of distressed mergers and acquisitions. Now, this might seem an odd topic to do in a subject about mergers and acquisitions, given that for almost the entire course, you're going to be talking about situations where you have companies that are solvent, that are being merged or that are being taken over. And this topic really doesn't fit neatly within that. This is quite a different topic. But we thought that it might be useful for you to consider really another way to try and take over a business, which is to buy it out of an insolvent situation. So that's what we're going to be talking about in this particular session. And we're going to be working our way through the voluntary administration provisions in Chapter 5 of the Corporations Act. So here are the things that we're going to be talking about in this short discussion on distressed M&A. So I'll take you through some standard strategies that can be used under the voluntary administration provisions for distressed M&A transactions. I'll talk a little bit about debt for equity swaps using deeds of company arrangement, and we'll have a particular focus on Section 444GA of the Corporations Act. So it will be useful if you have Section 444GA available to you as you're going through and watching and listening to this particular topic. We'll focus on the distressed M&A transactions involving listed vehicles, and that's certainly something which has generated a lot of debate in the M&A community, the capacity to buy out listed companies and potentially affect tens, if not hundreds of thousands of shareholders. I'll take you through the Channel 10 restructuring, and we'll talk about what happened there and with the outcome in that particular case. That's one of the more significant distressed M&A transactions we've had over the last couple of years. And then I'll talk a little bit about some broader implications for the use of voluntary administration as a distressed M&A tool. Okay, so let's talk a little bit about the role and purpose of voluntary administration. So I know this is not an insolvency course, but you do need to have an appreciation of what VA is and how it works in order to better understand how it can be used for distressed M&A transactions. So the typical insolvency procedures under the Corporations Act are liquidation, where basically the company is insolvent, a liquidator is appointed, they sell all of the assets, which could involve selling the business as a going concern, but often is just auctioning off the individual assets on a piecemeal basis, and then they pay the creditors as much as they were able to from those proceeds. Voluntary administration is different. So with a voluntary administration, you're trying to save the business if you can. That's the first priority. If you're unable to save the business or as much as possible of the business that can be saved, then the legislation through Section 435 capital A says that you need to try and get a better return for the creditors and the members than you would get in an immediate liquidation. So the idea is you're comparing administration against the liquidation outcome. Now that'll be important when we look at some cases where the courts have had to determine whether the equity has any value for the purposes of assessing whether the shareholders are prejudiced by orders from the court to force them to transfer their shares to new owners of the business through the distressed M&A docker. So that's the goal of administration. Try and save the business if you can. Give the company a bit more time to try and sort out its options. Although administration is supposed to be a relatively short time frame, typically lasting around about 6 weeks to a couple of months, there is the facility to go off and ask for a court extension of the what's called the convening period, which is the period of administration leading up to the second creditors meeting, when the creditors then have to vote on whether there is a restructuring proposal through what's called the deed of company arrangement, or whether they will vote to put the company into liquidation. So where you've got a complex transaction, think like very large, complex companies like Arium, the big steel maker that went through administration a couple of years ago. Channel 10 was quite a big one as well. That went for a few months. Where you've got a very large transaction like that, it is possible to get a court extension, possibly for 6 months, 8 months, a year. We've had some sale campaigns run through administration that have gone for more than a year, where the time has been needed to really get the business in order to put it in the best position to sell the assets. So the whole point about administration is it's quite flexible. The court is able to make a variety of orders under Section 447A to really suit the specific needs of that particular company in administration. So the idea is that you're trying to save the business, so you're trying to preserve the goodwill, you're trying to maximize the enterprise value of the business by working through your work in progress, preserving contractual relationships, and then trying to get the business into proper shape so that it can either be sold or you're able to deal effectively with its balance sheet problems through a deed of company arrangement, which typically would involve some sort of variation of the terms of different classes of debt, although you can't bind secured creditors through a deed of company arrangement. So it could be cancelling some debt, it could be rescheduling some debt, it could be just changing the nature of the payment terms of unsecured debt. So you can use a DOCA in a pretty flexible way to try and deal with the specific unsecured debt problems that this company has. Now, if you need to deal with secured debt problems, so for example, if you're looking at a syndicated loan where you haven't got the requisite majority needed to vary the relevant terms of the loan, then you might want to look at a scheme of arrangement. And that's what we've seen in some other major distressed M&A transactions. For example, the restructuring of Channel 9 a number of years ago, the restructuring of what was then Centro shopping malls, which is a very, very large transaction a few years ago, and the restructuring of Alinta Energy a number of years ago. So if you don't need to restructure secured creditors, then a voluntary administration using a deed of company arrangement can be an effective tool. If you do need to restructure secured creditors, particularly against their consent, then a scheme of arrangement is what you should be looking at. So one of the issues that can come up in an administration is, well, how do we know if sufficient value is being provided? So we might have a new owner who wants to come in and recapitalise the business. They want to acquire the shares in the business. How do we know that they're providing proper value? So the typical point of comparison is a liquidation. What would happen to the company and its creditors and the shareholders if the company entered liquidation straight after the administration? And often in these types of situations, the company would have very minimal value in liquidation. So one of the things that I'm sure you're aware of in the modern economy, there's a lot of businesses out there that don't have a lot of fixed assets that they own anymore. There's a lot of leasing arrangements. The value in a lot of businesses these days is intangible assets, intellectual property, franchising rights, the value of the people that are working for them, and particularly the value of contracts. So administration provides a pretty flexible procedure whereby the administrator can negotiate with the key stakeholders, come up with a restructuring plan, and hopefully provide some proposal that the creditors will find acceptable. We'll deal with the company's debt problems in an effective way to allow it to continue trading and hopefully return to profitability. Now, you can discriminate against particular creditors in a voluntary administration. You just can't do it unfairly. So the typical way to determine whether that discrimination is unfair is certainly looking at the creditors as a class. So are you treating creditors who have the same priority ranking in a similar manner? And are you treating them in a way which is consistent or better with how they would be treated in liquidation? So you can't really use administration to try and take away rights that creditors would be able to exercise in liquidation. And it's very difficult to vary the priority that creditors would get in a liquidation unless you get their consent to do so. So there are some limitations on that. Now, the interesting question is, well, where do the shareholders fit into this situation? And even though the purpose of administration in 435A says that the goal is to try and provide a better return for the company's creditors and members, really members don't get much of a look in an administration. So they're unable to trade their shares. And as we'll see in a moment, it's possible to use a deed of company arrangement to force them to give up their shares. So members don't get to vote. There's not a lot of rights that shareholders get in voluntary administration, basically. Okay, so now let's have a look at some common M&A strategies that we see in voluntary administration. So first point, just distinguish between, are we buying the business assets or are we buying the shares in the company? And there might be a number of reasons why we want to draw that distinction. So there might be some adverse tax consequences, depending on which way we go with that. It might differ depending upon whether the buyer is a foreign national or not, thinking about issues like Foreign Investment Review Board type questions. And also, how will any remaining tax, not tax credits, but tax losses in the business be treated, for example, if we're able to buy the shares? So there might be some value there if the business has been losing money over time and you want to take advantage of those tax losses, then you might be able to satisfy the continuity of business test for the purposes of carrying forward those losses if you go in and acquire the shares. The administrator is able to sell the business at any time, so they don't actually need creditor approval to sell the entire business to a new buyer who's going to come in and recapitalize it. Now, of course, that would not involve selling the shares. They can't force the existing shareholders to sell their shares, but they're able to do that if they use a deed of company arrangement and they then get a court order forcing the shareholders to sell their shares. But the court will only do that if the shares have no value, basically. The administrator is also able to sell the business assets through a deed of company arrangement, and we saw with the Arium example, literally dozens and dozens of companies were basically consolidated, had their assets consolidated and the claims against them consolidated and then dealt with through a deed of company arrangement, which was able to provide, in that case, the purchases of the business, the GFG Alliance, the purchases of the business basically with a relatively debt-free new entity. So that can be a very effective way to take over a business by going into a deed of company arrangement and then having the administrator agree to the terms to buy those assets. It's also possible to use what's called a holding deed of company arrangement, and basically what that means is the administrator needs to do some further investigations, they need to do some further work on a deal, and so rather than voting on a final proposal, the creditors just vote to give the administrator more time. So the purposes of the deed is actually just to give more time to try and sort out a better commercial outcome for the creditors. And there'll be some protection mechanisms in there in terms of the deed not lasting for years and years. There'll be reporting obligations on the deed administrator, and the creditors will have the capacity to terminate that deed and put it into liquidation if there's not sufficient progress according to the expectations laid out by the administrator. So now let's talk about the use of debt for equity swaps in voluntary administration. So what we're talking about here is we're trying to fix the company's debt problems by swapping the majority of its debt for equity in the company. So the administrator can do that, for example, by issuing new shares during the period of administration. The problem with that, though, is that you're not then dealing with the existing shareholders. Now, it is possible to issue a sufficient number of new shares that you effectively make the existing shareholders irrelevant. And we saw that in a case called New Bounty back in 2015, I think it was, where the creditor, major creditor who was recapitalizing the business, basically issued 1 billion new shares. And that took the existing shareholders down to 0.03% of the votes in a meeting. So that is possible. The tricky thing for the administrator doing that, though, is if it's the administrator causing the company to issue shares, then of course the issue of those shares is going to be subject to fiduciary duties and statutory duties. It's probably better to get the directors to issue the shares, and that way the risk is on them rather than on the administrator. The deed administrator might be able to issue shares, but only if the deed itself confers on them that power, because the default provisions for deeds of company arrangement that are set out in Schedule 8A of the Corporations Regulations don't otherwise allow the deed administrator to issue shares. But again, the directors can issue shares. So part of this distressed M&A transaction, which is trying to recapitalize the business through new ownership, is about working with your existing management, working with the proposed buyer of the business, and then trying to put the business into shape where you can then effectively transfer the assets to the new owner. And of course, this is leading us up to 444GA, which is a court order forcing the existing shareholders to sell, not to sell, but to transfer their shares for nothing to the new owner. So on this slide, I've got some case examples where we've seen some debt for equity swaps using a deed of company arrangement. So New Bounty, I mentioned a moment ago, that was where the owner of the business who was recapitalizing it basically issued 1 billion new shares to take over the business. Blue Energy was another interesting example where we had a second tier secured creditor basically try and buy it out of a deed of company arrangement that was already operating by then trying to issue new shares. Now, in that situation, the deed had already issued new shares to the senior secured creditor, and it was the junior secured creditor who then said, oh, well, now I'm the only senior secured creditor, so that means that I control the assets. And they actually appointed a second administrator while the company was already in a deed of company arrangement. In that particular case, the court removed the second appointed administrator so that the original deed administrator could continue on with the restructuring of the business for the benefit of the new owner. And then there's been a growing number of public companies that have then gone through the 444GA court approval process to get a court order to force the existing shareholders to give up some or all of their shares to the new owner of the business. Now, the reason you might want not to get the shareholders to give up all of their shares is if you're dealing with a listed vehicle, then the ASX listing rules have a minimum shareholder spread requirement. So you actually don't want the shareholders to have to give up all of their shares, because you then might fall below the minimum number of shareholders that you need to have under the listing rules for a listed company. So, for example, in Mirabella, the shareholders were required to give up something like 99% of all of their shares. Okay, so in terms of the loan-to-own strategy, that can involve a number of different elements, and this is really leading us up to the Nexus Energy example. Often what we're seeing here is the party who wants to take over the business is then buying into the level of the company's capital structure where the value breaks. So that might be at the senior secured lending level. So you might see the new owner of the business who's buying out the existing bank, for example, or the existing senior finance provider, or it might be in a situation where we've got some secured notes, which is sitting there in the mid-levels of the company's capital structure, in a situation where the senior secureds are over-secured, so there's no risk to the value of their loans, and the value breaks really at that intermediate level in terms of the security. So that's a common strategy where someone who really wants to buy a business buys up some of the senior debt, and that then allows them to exercise some measure of control and influence over the company. And what we might see, and what we've certainly seen in examples like Nexus, is where that buyer is adopting this loan-to-own strategy so that they're buying into the senior debt level. They can then put a credit squeeze on the company, which then effectively forces the company's hand so that the directors are then almost compelled to appoint administrators because they risk insolvent trading liability. And that can then allow the party who really wants to buy the business out of insolvency to then negotiate with the administrator, or if they've got security, to put in their own receiver for the purposes of restructuring the business and trying to take control. Okay, so that brings us to Section 444GA. Now, this is a relatively new provision. It was introduced at the end of 2007. And the reason it was introduced was to provide a bit more flexibility in terms of outcomes using a deed of company arrangement. So earlier in the discussion, I mentioned to you that we need to draw a distinction between situations where we want to acquire the assets of the business versus situations where we want to acquire the business itself, that is the company that owns the business assets, and so we need to acquire the shares in order to implement that restructure. So Section 444GA was introduced to allow that to occur. So DOCA administrators can get a transfer of shares to facilitate a distressed M&A transaction if they have the consent of the shareholders, obviously. But if they don't have the consent of the shareholders, then they can get the permission of the court. Now, the court can only grant an order forcing the existing members to transfer some or all of their shares if the court is satisfied that the transfer would not unfairly prejudice the interests of the members of the company, and there's various parties who are giving standing to oppose the application for that order. So now we start talking about some cases on 444GA. So the first case on the section after it was introduced was Weaver and Noble Resources. So this was basically a company that owned a very large mining site. The mining site was essentially on care and maintenance because of where the commodity prices were at the time. And a new owner was proposing to come in and recapitalise the business and restart the mine. Noble Resources was one of the only shareholders, so it was a closely held company. And essentially their argument was, well, our shares must have value because someone wants to acquire them. Now, they refused to consent. The court in that case ordered the transfer of shares on the basis that if the restructure did not go through, then the alternative almost certainly was liquidation, in which case Noble's shares would have no value. And that was a really important decision because that's really set the scene for how this section works in terms of distressed M&A transactions. So after Noble Resources, the next really significant case was the case of Mirabella Nickel. Now, Mirabella Nickel was a listed Australian company that had assets in Brazil, mining assets. And again, due to changes in commodity prices, ended up in a situation where it was over-levered, it had too much debt, it wasn't getting enough money out of its Brazilian mine to justify the interest payments that it was making on its various debt obligations. And so some of the note holders in that case, particularly out of the US, decided to offer some new bridging finance and then to essentially do a loan-to-own distressed M&A transaction where they would then take over the business through a deed of company arrangement. That involved requiring the existing shareholders to transfer 98% of their shares to the new owners. The company had undertaken an extensive sale campaign before the DOCA was proposed, and so they had a good idea of what the assets were valued at in terms of their market value, and the court approved that, approved the transfer. Now, that worked for a while, but then again, changing commodity prices, and unfortunately Mirabella ended up in insolvency again a bit over a year later. The significance of this case is that we had a listed company that had literally tens of thousands of Australian shareholders, and basically they've just received a notice, hey, the company's insolvent, you have to give up your shares for nothing. And the court was prepared to apply the section and say, well, that's because the shares are worth nothing. If this restructure doesn't go through, there's no other deal on the table, and that means then that you'd end up in liquidation, and on a liquidation you'd be guaranteed to get nothing because there's far more debt than there are asset values at this point in the absence of any other restructuring proposal. That brings us to Nexus Energy. Now, I think this is quite a significant case. It was another very large and complex situation. This is really a very sophisticated loan-to-own distressed M&A strategy. And Nexus actually was a dual-track M&A transaction because the acquirer of this business tried a standard merger approach using a scheme of arrangement which offered literally cents per share. The shareholders rejected that, and so then the second stage strategy was to use a distressed M&A approach. So the company that acquired it, that basically Seven West, had, through its associated companies, had bought out the company's secured debt. Nexus Energy was involved in several energy projects, large infrastructure projects, and unfortunately they needed further capital expenditure, which they just didn't have the money to pay. Now, if they didn't complete those projects, then they wouldn't realise the value, and there was very substantial value in completing these projects. And there were buyout provisions in the joint venture agreements, which would allow the joint venture partners, if Nexus failed to complete their end of the transaction, could then buy them out. So there was a lot of value here, but the company faced the problem that it just didn't have the money to complete the projects. So Seven West decided to take them over. After the rejection of the scheme of arrangement by the shareholders, they then essentially put a credit squeeze on them. And at that point, essentially, there was no other option for the directors but to appoint administrators. That then allowed the Seven West associates to propose the deed of company arrangement. So they're essentially controlling the secured debt. Secured creditors aren't bound by a deed of company arrangement. They're also proposing to buy out the business. It's the only offer on the table. It at least provides some value for creditors. And in this case, the court then had to go through fairly detailed and complex competing valuations. So the existing shareholders said, well, look, these assets are potentially worth hundreds of millions of dollars. They're trying to buy the assets on the cheap. If the court refuses this application for a 444GA order, then what would be likely to happen would be that Seven would have to come back with a better offer. That was the argument of the shareholders. The court said the problem with that is there's no other offer on the table. So the comparison is not between the existing offer and a potentially better offer, but rather between the existing offer and what would be likely to happen if the existing offer failed, which is liquidation. And on a liquidation, there would basically be it would be very, very bad for the creditors here, and certainly the shareholders would receive nothing. So this is a significant case because we had a highly contested valuation, but the court agreed that essentially a liquidation valuation was appropriate here, even though the assets had potentially hundreds of millions of dollars in value, but they needed those extra funds in order to realize that value. And because the acquirer also controlled the senior secured debt, then there wasn't much that could be done here. Okay, so over the next couple of slides, I've just extracted some quotes from some of the leading cases on 444GA. So on this slide here, we've got some quotes from the Weaver case, which, as I said, was one of the first cases to really look at Section 444GA. You'll see there, for example, down the bottom, a mere transfer of shares without compensation cannot of itself constitute unfair prejudice. Otherwise, the section's operation would be significantly constrained. So as long as you can establish that the equity has no value, then it's not going to be unfairly prejudicial simply because you're not paying for the shares, basically. Then here we also see recognition from the court in Weaver that the purchaser of the business that's in financial distress is obviously taking some risk, and it's not fair on them to have to bear that risk if the existing shareholders basically could require some sort of green mailing benefit out of this situation. And here we see a quote from the Mirabella Nickel case, just emphasizing that the comparison is between the deal that's on the table to acquire the business versus what's most likely to occur if that deal isn't approved. There's also a quote there from the BCD Resources case, and in that particular quote there, the court's emphasizing, well, look, if the shareholders don't agree with the valuation, if the shareholders have some other grounds that they can argue that the court order to transfer their shares to the new owner is unfairly prejudicial in some other way, then they need to be given that opportunity. But assuming they are given that opportunity, it's not going to be unfairly prejudicial just because they're being forced to give up their property for nothing, because that's exactly what the legislation says. So unfair prejudice, as we can see here from the quote from Diverse Barrel Solutions, the court will have regard to all of the circumstances. And this idea that the court, assuming that the shares have no value, the court isn't just looking at economic values, it's going to look at all the circumstances and what's going on. This was something that came up in the Channel 10 restructure, which we're getting to in just a minute. And here we can see the court in Nexus. You've got to have regard to the purpose of administration, trying to save the business. If this is a recapitalisation proposal that's going to keep the business going, then that's one of the purposes of administration. So I guess what to take from this, from your perspective in this mergers and acquisitions course, is obviously mergers and acquisitions is mostly focused on the equity, and it's mostly focused on solvent businesses. What we're talking about here is that you can achieve similar outcomes. You can take over the control of a company by putting pressure on its senior debt and then effectively maneuvering the company in terms of having control over that debt so that the company is in a position where it basically has to go into insolvency. And then if it goes into administration, then you're able to put forward a proposal as a senior secured creditor. You're not bound by the deed of company arrangement, and you're able to effectively try and buy out the assets. So now we get to the Channel 10 case. This was one of the larger restructurings that we've seen in the last few years. Channel 10 had literally billions in debt. It had very little by way of hard assets. It was also an interesting company because it was controlled by billionaires, basically. So there were several different shareholders involved in Channel 10 who were very wealthy and very experienced business people. And we effectively saw a contest between, it ended up being Channel 10's major supplier, CBS, the big American television station, and its major shareholders in terms of entities associated with Bruce Gordon and Lachlan Murdoch. So Channel 10 had been losing money for a long time and really had only maintained its solvency by the use of guarantees of its corporate senior lending facility with the Commonwealth Bank through its major shareholders. So it reached a point where the major shareholders no longer were prepared to provide that guarantee. And so once they notified the company that they were going to not renew the guarantee with the Commonwealth Bank, then that basically put the directors of 10 in the position where they had to appoint administrators, because 10 didn't have the financial capacity to repay the CBA facility, which was coming up for expiry at the end of 2017. And neither did it have very substantial assets that it could then go and pledge in order to obtain further bridge funding. So initially there was a proposal from the Lachlan Murdoch and Bruce Gordon interests, and that was timed to fit within the duration of administration, so that the administrator would have to make a decision on that offer before the second creditors meeting. Now the problem was that they then didn't extend the offer. So a counter offer was made by CBS, and the CBS offer promised to keep all of the jobs but would wipe out the equity through a 444GA. Now, the Murdoch and Gordon proposal would also wipe out most of the equity through a 444GA order in a DOCA, but would also promise to preserve at least 20% of that equity. So there were slightly different pricings, but the big difference was that shareholders would lose everything with the CBS deal, whereas in the Gordon and Murdoch proposal, the shareholders would retain some value. So this was an interesting case where potentially we would have very different competing valuations on the business. The expert valuation showed that it was hopelessly insolvent, that even on a best case scenario, it was highly unlikely to be solvent in the absence of a major debt restructuring. And that was what CBS proposed. So the big benefit with CBS was that they had a claim for $1 billion, which was essentially their 10 years worth of new television programs being supplied. So they agreed to not include that debt as part of the administration. And that was then a huge relief in terms of getting the DOCA across the line. So even though they were far and away the major creditor, by agreeing through the DOCA that they would not enforce that obligation, that was a huge debt that was then removed from the company's financial position. Now, there were some issues with the operation of this distressed M&A because the company got in Cordamenta, the large insolvency firm, and they were engaged through the company's lawyers, and they were engaged specifically to do a review of the business and establish the different lines of financial reporting with the view that if everything failed, then they would be ready to go in an administration pretty quickly. And there were some concerns about whether or not they were sufficiently independent because they had been working with the business for many months before they were appointed as administrators and had basically billed $1 million in fees. Administrators are supposed to be independent. So I guess that's one difference with a standard equity M&A transaction is your advisors aren't usually completely independent in those scenarios, but an administrator has to be seen to be independent. Now, in this case, with some additional disclosure, essentially setting out everything they did for the company, they weren't advising the board as to what they should be doing. And so the court was satisfied that they were, in fact, independent. So this was quite a good outcome for major restructuring efforts because it recognises that you can get in and do some work beforehand so that you can maintain continuity of the business through the administration period. Because obviously if Channel 10 had simply turned the TV screens off, the business evaporates. So you need the capacity to keep trading the business to preserve that goodwill and to preserve all of the other contracts that they would have with various suppliers. Now, prior to the creditors' meeting, the Gordon and Murdoch interests challenged the administrator's report. And this is one of the reasons I selected this as a case study for this topic, because a lot of the arguments that they raised against the report to creditors, were that the report to creditors was not as detailed as what you would expect in, say, a takeover offer under Chapter 6D, under a Part A statement, for example. So they pointed to a lot of supposed deficiencies in the report. There could be more detail here, more detail on that, further valuations here, further independent assessments here. And essentially the court came to the position that, well, actually this isn't a standard takeover. We don't have 6 months to run through an exhaustive due diligence process. The company is basically a melting ice cube and the administrator has to work quickly. So the report is as good as the administrator could do within the very limited time frame that they had to operate this essentially insolvent business. So I think that's quite an important point. The distinguishing between a standard equity M&A and a distressed M&A is that you're operating on a much, much shorter runway. with a distressed transaction. That the idea of the melting ice cube, the longer you take, the less likely you're going to get a good commercial outcome, really helps frame the nature of the reporting obligation. So we can't expect to treat this like a standard equity M&A, even if, for example, like in the Nexus Energy case, it started off as a standard equity M&A proposal through a scheme of arrangement, and then you switch essentially to Plan B to go through the insolvency distressed M&A transaction. Now, the Gordon and Murdoch interest tried to basically prevent CBS from voting, arguing that it was a related party and that it was trying to kind of pull the wool over everyone's eyes. And essentially how the court resolved that was to say, look, these matters were such high profile that they were extensively reported on. The creditors surely would have been aware exactly who CBS was, similarly would have been aware exactly who the Gordon and Murdoch interests were. And so rather than prevent the creditors meeting from going ahead and ordering the administrator to provide further information, it'd be open to the creditors to adjourn the creditors meeting and then request further information. Now, of course, they didn't do that. They held the meeting. It was overwhelmingly voted to support CBS. And now, of course, we have a very viable Channel 10 network, whereas we could have had Channel 10 in liquidation. Okay, so some of the other issues in this Network 10 case. So there were some concerns about the fact that shareholders weren't being given a vote, and shareholders did actually turn up to the court hearing and oppose the 444GA application after the other creditors voted to support the transaction. And the court said, well, that wasn't a reason to stop the creditors having a vote on this. There are provisions in the Act that basically strictly subordinate the position of shareholders as creditor claimants in voluntary administration. So that's a reference there to Section 600H. There's also Section 563 capital A. So shareholders have subordinated claims. If they've got any claims against the company that arise from their capacity as members, then they're strictly subordinated. So the court said, well, there's no problem there not giving the shareholders a vote on this proposal because their shares are worthless. The KPMG report showed that it was highly unlikely in the absence of this restructuring proposal that Channel 10 would be solvent in the medium term. And we've seen that in some other distressed M&A type transactions, even outside of administration. The courts have recognised that shareholders don't get to vote on these things. They're not a standard equity M&A transaction. And then just some final issues here. One of the interesting aspects of this transaction was that CBS bought out the CBA's debt facility. So CBS was the major creditor who was pushing the recapitalisation proposal through a debt for equity swap to take over the business. They're also the major secured lender after buying out the CBA. And so they also put the receivers in. Now the receivers entered into an agreement with the administrators whereby they gave the administrators gave the CBS exclusive rights to negotiate the sale transaction. So the court said that there was nothing untoward about that. An important point to stress here, if you don't recall the events, is that the Murdoch and Gordon proposal had lapsed. And although there was a lot of speculation that they would put a new deal out as an offer, they didn't at the time. So the only deal that was available was the CBS deal. And so the court said, well, in those circumstances, there's not a problem having them enter into some sort of exclusivity arrangement. So the Network 10 litigation in 2017 was very significant in terms of distressed M&A transactions. We saw the court discuss some very flexible powers that it has under the voluntary administration provisions. We also saw the appointment of a special investigator with respect to certain things that KordaMentha had been involved in terms of how they were reported to creditors prior to KordaMentha being appointed as administrators. So there was some concern that ASIC had raised about if the fees that KordaMentha had drawn prior to being appointed as administrator could then be subject to avoidable transaction proceedings if the company entered liquidation, that there should be a special investigator for that to report to creditors. And of course, they didn't report that there was anything that could be taken back there. We saw the court recognise that this is not like a standard M&A transaction. This is on a compressed time frame, a much shorter runway, and so we have to adjust the expectations for distressed M&A disclosure in particular. The recognition that shareholders don't get to vote here, although they can oppose the Section 444GA application. And I guess a recognition that the levels of disclosure obligations that we see here are just not as onerous as we see in a standard takeover contest under public M&A provisions like Chapter 6 and mergers under schemes of arrangement. So the Network 10 case, that just rounds off the use of Section 444GA as a distressed M&A tool. So I hope that was useful, and I'd encourage you to think about some of the themes that we've talked about here in terms of the value of disclosure, who gets to vote on transactions, the duration of time that you have in order to undertake investigations and prepare reports, particularly independent experts' reports, valuations, just the onerous nature of the due diligence requirements that you see in a standard equity M&A, and then compare that to a situation where really you've got a melting ice cube in terms of the company that's in financial distress. But cases like Mirabella and Nexus and also Channel 10 show that a loan-to-own strategy using a debt for equity swap through a deed of company arrangement can be an effective way for a party who wants to take over a business, effectively taking it over, not by buying up the shares on the public market, but by kind of cornering the business into insolvency and then buying the assets out of insolvency. So I hope that was useful.